It's always fun. We shot $8 a gallon.
That's the other thing.
Good evening, everyone. I'm going to call the Coastal Resources Management Council's Rights of Way Subcommittee meeting to order. Today is Tuesday, June 27, 2023. I'd ask that the record reflect the council members that are in attendance, as well as staff members that are in attendance. Our first matter on the agenda is a staff report and approval of the minutes for May 23, 2023.
No staff report tonight.
And the minutes for May 23, 2023.
Second.
Motion made and seconded to approve. Any discussion? Hearing none, all in favor say aye. Anyone opposed? Motion carries. First matter will be the Spring Avenue right of way. I'm going to call on Attorney DeSisto to give some brief introductory comments.
The matter is down for motions to intervene for Carolyn Contrada, represented by Attorney Michael Rubin, and also motion to intervene by the Attorney General on behalf of the public. There are objections to both. I think it's appropriate at this time to take both motions to intervene and vote on them. And depending upon what the decision is, we can proceed with one other procedural matter on this in connection with it. And hopefully this will make it so these preliminary matters on this issue can be disposed of and we can start thinking about scheduling hearings. My suggestion is that we start with the first motion to intervene that was received by the subcommittee, which would be by Mr. Rubin on behalf of Ms. Contrada. And I did see Mr. Rubin here.
Thank you. If I can approach. Michael Rubin for Caroline Contrada. Caroline Contrada actually has two attorneys, myself and Sean Minor. Sean would stand up. So Sean will be joining me in representing Caroline Contrada.
Would Mr. Linus like to come up with you?
I would like that.
Thank you.
Moreover, in the audience tonight is Caroline Contrada herself, a Westerly citizen of long standing and a beachgoer. That said, I think, my motion speaks for itself. It's 10 pages. I didn't elaborate on the facts that we intend to prove. I don't think that's the time or the place. I just spoke to Caroline Contrada's interest, which is the interest of a citizen of Westerly in maximizing beach access. I read the opposition. Respectfully, I have to disagree. There are some things where they seem to go into the merits of the case, talking about how this path has been blocked since 1939, and then it's been fully blocked. I think that's what we're here ultimately to decide. So I don't think you can, in a circular fashion, predicate opposition to a motion to facts that haven't been established one way or the other yet. I understand that Caroline is but one member of the public, but she is a member who happens to be represented by two attorneys. At least one of us, Sean, is an excellent attorney, and I think can organize and present the evidence. And I think the sweat equity has been put in on the part of Sean and I in this case to indicate that Caroline Contrada should have the extra advantage of intervention above and beyond perhaps what other members of the public will be afforded. With that, I'll yield unless Sean has something to add.
Do any board members have any questions for the attorneys?
Patricia?
No.
I do not at this time.
May I ask a quick question?
Absolutely.
Can you articulate how Ms. Contrada is, if at all, is a party in interest to this matter?
As I briefed in the memorandum that I submitted, I think there's a distinction to be made between standing, especially standing in a court, and intervention in an administrative proceeding, the contours of which are supposed to take into account a variety of interests and a variety of public interests. So I would say that as an interested member of the public who has put in special time, special effort, gone through the trouble of retaining 2 attorneys, I think that, she satisfies the need of an administrative agency, especially one such as CRMC. In my memorandum, I cite the webpage or the website of the CRMC, which places a huge amount of emphasis on members of the public, coming forward with information, with analysis, with expertise, with documents. Caroline is such a citizen. She happens to have 2 attorneys, which will help her organize and present the evidence. And I think that's sufficient in an administrative context.
Thank you. Well, I think it's appropriate to hear the objection now by the Weekapaug Fire District. Mr. Farside's here, and
Ms. Lancy.
Ms. Lancy.
Thank you, Counselor. Good evening, council members. Joe Farside and Alex Lancy on behalf of the Weekapaug Fire District. Couple things to start. This proceeding is before the subcommittee to conduct the narrow statutory duty of designating whether a pre-existing right-of-way is already public or not. The CRMC, under its own rules, cannot create new rights-of-way. We have the motion to intervene of Ms. Contrada. We in the district do not doubt her intentions or the capabilities of her counsel. But Councilor DeSisto has already indicated at the last hearing that the subcommittee is able to hear from members of the public without giving them intervener status. Intervener status will confer upon a member of the public with no unique eye or aspect to this particular matter beyond what any other member of Westerly would have to not only put on evidence, but also examine and cross-examine witnesses and put on her own witnesses. And her motion to intervene attempts to, quote, adopt the ample papers previously submitted by attorney Michael Rubin. And we submit, those are already in the subcommittee's records, and we don't need Ms. Contrada, we don't need to permit Ms. Contrada's motion to intervene in order to have those materials on the record. So the public withstanding in and of itself, the subcommittee can hear from Ms. Contrada in due course, as Attorney DeSisto indicated on May 23rd. Adding yet another party to examine and put on witnesses, cross-examine witnesses is going to cause delay without a corresponding benefit from our perspective.
Any questions? No questions at this point.
Thank you, councilors.
Thank you.
Mr. Conley represents the town of Westerly, which is definitely an interested party, and he may want to speak also, and I think it's appropriate if he does.
Thank you.
Go forward.
Appreciate that. So William Conley for the town of Westerly. And as the subcommittee knows, the town of Westerly essentially referred this matter and brought this matter before you. It is the town itself that has asked that this issue be engaged and that this determination be made. And from that perspective, we would like to tell this subcommittee that we support this intervention. We think that the process will benefit from the unique position that Ms. Contrada takes, and as outlined in her memo and the affidavit in support of that. So we would respectfully request that you grant this motion in debate.
Thank you.
Thank you.
Any questions, like Mr. Conley? Okay,
Thank you.
you're welcome.
Would I think it's up to the subcommittee. Would they like to hear from the Attorney General and the objection on that prior to making decisions on both? Or would you like to take up the Entrada motion to intervene first?
What's your consensus? I think we take them individually. From what it's good to me.
I do. Yes, there are some things I actually want to bring up. I just
Okay,
unfortunately I have to go to the computer. And that's always an issue. But you know, the question is whether or not an intervening party is a party in interest. Do they have an interest that should be represented in matters of this nature? I think one of the main objections coming from the Weekapaug Fire District is that with the Attorney General coming in for the general public, that there's no need for Ms. Contrada to intervene in the case also. I think one of the factors that the subcommittee has to take a look at is whether or not the allegations that were contained or I should say the statements that were contained in Mr. Rubin's and Mr. Linus's memorandum on this would show that Ms. Contrada, based upon those representations, in fact, has standings and may be considered separate and apart from the general public interest that the Attorney General will be arguing shortly. So I think if the subcommittee determines that Ms. Contrada does have standing and does have something to add to this, then the intervention should be granted. And I think it is definitely relevant and probative that the town of Westerly, which initiated this whole process, has no objection and in fact is urging that she be allowed to intervene. And if you have any questions, I'd be happy to answer them.
Any questions, Ron?
Can you explain like the difference between being an interventor and being a member of the public that makes fire? What the advantages or what the differences are in being an intervener?
Well, you know, as by the way, Mr. Forsythe relied on comments that I made that any member of the public is going to be able to speak on this. But unlike other members of the public, Ms. Contrada actually retained 2 lawyers on this thing. And, you know, we've been getting quite a bit of documentation from Mr. Rubin on this, which would indicate that perhaps she has more to say than just making statements at a hearing. And I think that's what the intervention is. I think what you can do is take into consideration the fact that research has been done on her behalf by lawyers that she's hired and directed to get to this point. And I think that's the difference between, or you know, showing up at a public hearing and making the statements on what your personal knowledge is and that. And I think she's gone a couple of extra steps beyond that. That's why she's asking to intervene.
Do we know, as an intervener, have they stated any intention of bringing other witnesses? I know that Mr. Forsythe had said, or Attorney Forsythe had said that that would be one of the benefits or the advantages to being considered an intervener, that she would be able to present witnesses.
Well, at the last meeting that we had, Mr. Rubin did state that he wanted to have depositions to preserve testimony of those who either couldn't make it or perhaps might not be around when this gets to a hearing. So I think the answer to your question is yes.
any other questions of Attorney DeSisto?
Anything else to add?
No.
No. The subcommittee, the position for motion, Mr. Gagnon,
I'll make a motion that we, based on Ms. Contrada being a resident of Wesley and having the support of the town and having already hired 2 attorneys, that we accept her as an intervener.
is there a second?
I'll second that.
Motion made and seconded to grant intervenor status to Ms. Contractor. Any discussion? Seeing none, I'll just hold the comments. Mr. Gagnon,
Aye.
Ms. Reynolds,
Aye.
I too vote aye. As it relates to that. So from our perspective, intervenor status has been voted and approved upon. Next is with the Attorney General.
Correct, yes.
Good evening, everyone.
Good evening.
Allison Hoffman for this Attorney General.
Ray Schultz for the Attorney General.
So most of our discussion was in our motions, but essentially, as we've argued in our motion, that there's common law authority that the Attorney General's office has the right to intervene on pretty much any and all administrative proceedings that relate to environmental and/or public access issues. Well, I'm paraphrasing. One thing I did want to comment on the objection was on the Berman case and the issues around whether or not there is a conflict that would arise of our intervention here. Just to kind of put a time frame on this, in 1970, that case was from 1977. In 1978, the legislature did pass Rhode Island General Law 1028, which allows for the Attorney General to intervene in administrative proceedings. And in fact, we have done so on many occasions since then. Unless my co-counsel has anything else to say.
Any questions, Ms. Reynolds or Mr. Gagnon?
No.
Tony, anything to add? Questions or
No.
comments? Is there an objector to that as well? I think we could pause.
There is, yes.
Thank you.
You're welcome. Well, the Weekapaug Fire District back up.
Good evening again, councilors. Thank you for the chance to discuss our objection to the motion to intervene of the Rhode Island Attorney General a bit more. As we set forth in our objection, the Attorney General's attempt to intervene in an administrative proceeding before an administrative body that it also will represent in court, should there be any appeals, presents a conflict. The Rhode Island Supreme Court was very clear about that. Perhaps the Attorney General's office is willing to recuse itself and allow other counsel to represent CRMC should this ever go to court. But with the Attorney General's office involved at the administrative level, it really deprives the Weekapaug Fire District of fair and unpoliticized proceeding. This is already a highly politicized matter, despite it being a property dispute with a narrow statutory mandate. The AG's intervention and social media presence thus far has done little to politicize this matter. We want to emphasize, based on my opening before, in connection with our objection to Ms. Contrada's motion to intervene, this is not a test case for shoreline access. This is an issue of private property rights. The Rhode Island Attorney General cannot itself point to an interest that's not already represented here. The subcommittee has just now granted the motion to intervene of Ms. Contrada, in large part or in sole part, but she has retained two lawyers and have submitted documentation on her behalf. We saw in the exhibit to the objection we filed that Ms. Contrada's lawyers are in close touch with the Rhode Island Attorney General's office. Now that that motion to intervene is granted, the public is already very well represented. In addition to the fact, as we discussed before, the public can come participate in the hearing process. The state should not have an interest here. This is part of CRMC's narrow statutory mandate, not a taking. Shoreline legislation is where this fight can and should happen. The final thing I'll say is that there were some sweeping statements made in the AG's motion to intervene along the lines of this so-called extension of Spring Avenue has been used for generations by fishermen and other beachgoers. We have submitted multiple APRA requests seeking the basis for that language, which was included in their December letter to the subcommittee. We have since received no support for those statements. We are looking for a fact-based, unpoliticized hearing in this matter. And allowing the motion to intervene of the Rhode Island Attorney General would cut against that. Thank you for your time.
Thank you. Any questions? The Gagnon or Ms. Reynolds?
May I ask a question?
Sure.
You know, my, I think the last time the agency was in front of the Supreme Court was on the Champlin's case. And on the Champlin's case, the Attorney General had intervened. That was really the subject matter of that case. And when it was argued in the Supreme Court, the Attorney General wasn't there for the agency, of course, was in fact arguing on the opposite side of the case. That was not an issue in that case. And I'm not really aware of any case law where the Attorney General automatically represents agencies such as the Coastal Resources Management Council in matters of this nature. Can you comment on that?
Sure. The statute is clear that the Attorney General can serve as counsel to CRMC should matters that were before the council wind up in court. In the Champlin's matter, I'm not privy to any of the decisions that were made there by the parties involved, whether or on what grounds to challenge the AG's involvement at any point in time. And there very well could have been a sound reason not to challenge the AG's involvement at a particular point in time that resulted in the AG having intervened in whatever capacity intervened in. That's a wholly separate case. Here, if the AG is going to be part of this proceeding before the subcommittee as an intervener, putting on its own witnesses and pursuing its own agenda, then when we get to court, whoever winds up appealing the outcome of this matter, we would submit the Attorney General's office would be conflicted out of then representing the CRMC at that stage. It's in our view, a basic conflict of interest.
Well, it's 5:27, and I could go into exactly what happened in the Champlin's case, but we'd all get out of here at about 11 o'clock at night.
Sure you could.
So we're not going to do that. Thank you.
Thank you.
Thank you.
I think Mr. Conley wants to speak also.
Yes, Mr. Conley, please.
Again, William Conley to the town of Westerly. At the risk of repeating the same theme and the same position. But for the completeness on the record, as you know, the town of Westerly has requested that this determination be made by. That's what, again, has brought us all to this hearing process. And as the party who made that request, I want to affirm for the record that we strongly support the intervention of the Attorney General's office in this matter and would request that you act favorably this evening on that request for intervention. Happy to answer any questions on behalf of the town that I can.
Any questions of Mr. Conley, Mr. Gagnon, or Ms. Reynolds? Attorney DeSisto? Okay, thank you.
Thank you.
Anyone else?
Oh, yeah.
Well, go ahead.
Well, in this instance, you have members of the general public that are very interested in this application. And if you remember at previous meetings, question was, there's lawyers involved in this and who will be representing members of the public? And the Attorney General fills in for that function. And there are instances in the past, which I'm aware of, where the Attorney General has intervened in administrative proceedings such as this with CRMC to make sure that the public's interests are adequately addressed in this instance. As I take a look at section 42-35-1 and parties in interest, one of the components from what we've seen so far is that there is not only a public interest in this, but that's part of the subject matter of this application. And that's how much public usage of this right of way will be determinative as to the final disposition as to what happens. I think that's why the Attorney General intervened on this. Part of the argument that we're getting from the Weekapaug Fire District on the first one was no to Ms. Contrada because the Attorney General is coming in, and no to the Attorney General because Ms. Contrada already is in. I do think the general public has interests that would need to be represented. The Department of the Attorney General is figuring to do that. So I do think it's appropriate at this time, particularly when we have the testimony from the town of Westley, which really initiated this at the CRMC. If you have any questions, be happy to answer them.
Any questions, Ms. Reynolds or Mr. Gagnon? Anything else, Tony?
No.
May I ask one question relating to something you just said? Is that okay?
To me?
To the council, you may answer certainly. You referenced the nature of this potential access point and the number of people that might use it. Is there something in the record that indicates how many people might use it if it was made a public right of way? If there is, I'm not aware of it, but I have only been involved in this case for a short period of time, so that's good.
Anything?
Sure.
We have this large record, and we've had members of the public actually come to the subcommittee to talk about their own usage. And that's one of the reasons why I'd like to get to the, I've kept asking that we get it to an agreed statement of facts on this. But I do think because there's this public component to what what needs to be addressed here, that's one of the factors that would be relied upon if the board wants if the board votes to have the Attorney General intervene. So I think that's one of the factors.
Thank you.
Thank you.
And by the way, there's people behind you raising their hand that want to address that, but it's not appropriate at this time. They're just members of the public that have been showing up on their own. So.
Thank you. Any questions, Ron or Tricia? Or in a position for a vote?
I'll make a
Motion.
With the representations and presentations made by the Attorney General's office and the representations made by the solicitor for the town of Westerly, I make a motion that we accept the Attorney General's office as an intervener.
Second.
Motion made and seconded. Any discussion? Hearing none, I'll poll the council. Mr. Gagnon.
Aye.
Ms. Reynolds.
Aye.
I too, Ray McCoy, vote aye. So the Attorney General has been granted intervenor status. What's next?
Yes. Next up is Mr. Rubin, who's now representing an intervener. And that is for your motion to request the deposition to preserve evidence, which was referred to earlier.
I think that the nature of the motion was in the form of a letter, which was filed back in January. I almost tend to say January 13th, date that sticks out in my mind, was to have the council subpoena Mr. McCann, who's the moderator, essentially the president, if you will, of the fire district. There hasn't really been action on the council. We've been engaged in what I consider to be good faith discussions with the fire district. I'm sure the Attorney General's office will now join those discussions. Hopefully those discussions will yield the need to, will yield a schedule for the taking of depositions, and perhaps Mr. McCann could be included on that schedule. And that would obviate the need to act on that motion. So I would ask that the motion be held in abeyance. We'll deal with it, cross that bridge if necessary when we come to it. I believe that the ongoing good faith discussion, which are constructive, will obviate the need for the council to act on that.
What I suggest the council do here is act on Mr. Rubin's request to have the matter held in abeyance with the proviso that it will not appear back on the agenda unless specifically requested to.
Okay,
I'll make that motion.
motion made by Mr. Gagnon,
Second.
seconded by Ms. Reynolds. Any discussion? Hearing none. I'll now poll the council, Mr. Gagnon, Ms. Reynolds.
Aye.
I too vote, Raymond Cohen vote aye on that particular motion.
Final matter is the scheduling order. So would the attorneys all mind coming up briefly? No, Steve, it's okay. Sit back there. That's all right. No, I
Who's trying to be first in line, Mike?
you know, it just jumps up, but the reason I'm doing this is there are members of the public here. I think it's important for them to hear what we're saying. And I know that Attorney General is just in, Mr. Rubin is just in, although he's been coming to meetings on a regular basis. But what the subcommittee has asked for is a scheduling order that would include an agreed statement of facts. Despite these preliminary matters that are not typical of when CRMC takes up rights of way on this, at some point, it will go on the statutory track, and there will be a public hearing down in Westerly on this, give you all an opportunity to say what you have to say and give the public an opportunity to say what they have to say. But in order to streamline the process, the request has been for an agreed statement of facts. So those facts that are not in dispute won't take up time for the public hearing and allow the public a better chance to speak. So if we could get a scheduling order for that, then we can start scheduling the public hearing or hearings down in Westerly so that we can proceed on the normal track that CRMC usually takes in matters of this nature.
And Attorney DeSisto, I'll take the lead in responding. First is we have a draft statement of facts that we spoke about over the phone with attorneys Conley and Rubin. Again, subject to the intervention, which has now been granted. That's about 8 or 9 pages long and tracks a lot of land evidence records and basic things that should not be in dispute. That's one component that we are working on. The second component is an actual agreement amongst council about when certain deadlines will be met and what they will entail. So when do parties disclose witnesses to each other? By what date do we have a chance to notice depositions if we want to take them? Any document discovery, although that should be minimal, and the like. And that's what we emailed to you yesterday to give you a flavor of where that is. That also came out of discussions between Attorney Conley, myself, and Attorney Rubin. So now we have the Attorney General's office added. We hope that doesn't slow things down, but we'll continue to work with everybody to get us an actual schedule in place of what will happen and get that statement of facts. We've been working on it.
Thank you very much. That would be the next topic to be addressed by the subcommittee. And I think once it seems they're going to be in agreement, once there is, then we can start thinking about mapping this out going forward. Thank you.
I just, a clarification, it's certainly not in opposition because I think Mr. Forsythe has done a lot to advance this in a very professional manner. But we haven't seen that proposed statement of facts yet. I know it's coming and I have no objection to that, but I just wanted to be clear that, Sean and I have not seen that yet, much less the Attorney General's office. So I know it's coming and we look forward to negotiating over that. But I do think that there are two tracks here. One, the agreed statement of facts, and the other is the procedural schedule for disclosures, exchanges, discovery and so forth. But I'm more optimistic on the second than I am on the first. Sitting here tonight, I find myself almost jumping out of my skin at some of the things that Mr. Farside might have said, and perhaps it's mutual, but I'm not sure that, we're going to get there on a agreed statement of facts. I don't think it's absolutely necessary. I think we will definitely get there in terms of a scheduling order, in terms of the procedures of this case.
Yeah, there's definitely going to be disputed facts.
Right.
What I think the subcommittee is looking for is to make sure that those where there's no dispute at all won't take up time at these hearings.
Right.
I know Mr. Conley likes to stay late in Westerly, but
The Attorney General is ready to jump in and will obviously advise accordingly once we have gotten caught up.
thank you. Okay, I don't have anything else.
Do we want to give a time frame or just hold it?
We'll put this down for control purposes at our next, when's the next meeting? Yeah.
Actually, the next meeting would be not until, well, we would have to schedule a separate meeting in July. Since we moved the fourth Tuesday meeting up to the 18th, it would either be on the 18th or we'll set a separate meeting.
I won't be.
Right, so it'll have to be a separate meeting in July.
Okay, we'll let you know.
TBD.
We'll let you know.
We're working on it.
Yep,
All right.
thank you very much for coming. We appreciate it.
Thank you.
Thank you.
There are two other matters, almost trivial, but and I think there's consensus on them. One is extremely trivial, but I did, on behalf of all counsel, other than the Attorney General, but not involved at that point, made a request to you, Attorney DeSisto, that there be a waiver of the requirement that we file things at CRMC headquarters in quadruplicate, in this era of email and PDF attachments. I think that electronic filing and service amongst ourselves is good enough, and I think all counsel agree.
Okay, it's not on the agenda. I don't want to get an open meetings violation from the Attorney General.
I think we should ask Ms. Turner what she feels about.
Okay, the other, perhaps not on the agenda, perhaps it will be on the agenda for next time, if it's going to be June 18th or whenever, is a very matter, not quite as trivial, but almost. And that is a request by Attorney Conley, representing the town, which referred this matter to begin with, that the caption be renamed In Ray Spring Avenue rather than In Ray Spring Avenue Extension. I don't know if that's on the agenda and therefore it has to be referred as well.
We'll make a determination on it. It's not on the agenda, though.
Okay. As far as, it was kind of me who stirred that up a little bit. They did drop some footnotes to that effect. So I'll just say that I do believe it should be restrained. That said, it is convenient to refer to it as Spring Avenue Extension, as to distinguish it from other portions of what was once Spring Avenue. So I have no problem with witnesses and counsel during the proceeding referring to it as that. There have been references to Spring Avenue Extension going back to right after the hurricane of 30. So I have to acknowledge that.
We'll take it up when it's proper to do so. Thank you very much.
Right.
Thank you.
Thank you.
Our agenda, right?
That's it.
That's it.
All right, entertain a motion to adjourn.
What is this, Mr.
Say a word.
Langseth, yeah.
On the agenda.
Richard Langseth, Bud Long Farm Road, Warwick. I'd like to propose that any documents that are sent to the CRMC are available to the public. For instance, if they have a draft statement of facts, that we're able to get a hold of it. Thank you.
Anything submitted to the CRMC is a public record. It will be made available to the public. Lisa's excellent at that.
Thank you.
Thank you. What's the motion to adjourn? Yeah, motion made, second to adjourn, all in favor, say aye. Aye, anyone opposed? Motion carries. The subcommittee meeting is adjourned. Thank you, everyone.
That would be something. Yeah. They act like that. Wouldn't get them. So I try to get at it quick. Go work for a doctor's office.
Good evening, everyone. I will call the semi-monthly meeting of the State of Rhode Island Cultural Resources Management Council to order. Today is Tuesday, June 27, 2023. First matter on our agenda will be approval of the minutes of the previous meeting, that being held on June 13, 2023.
I think I had one correction. I could be wrong on this, but I thought that bay that we were talking about with the oyster farm was Dago. They've got it, you've got it in here, I'm looking for it. You've got it in as Cedar Cove.
Mr. Willis is going to address that.
Mr. Chair, the cove within Potter Pond that the matter was referring to was Seeger, Segar.
Yeah. This
That's-
is cedar as in
Okay.
the tree.
Okay,
Not a big deal, but
sure. No, that's fine. We can make that.
I was thinking I was wrong all these months.